Are you ready to see my oral argument? You're going to be right there with me. This oral argument is still a rematch from when I did this the first time back in spring 2017 when I was a 1L and I did this inside of the law school classroom. However, this time around, we got to do it virtually because of the coronavirus. All good though. This oral argument is based on an appellate brief that I submitted last week in my legal writing class. I will be representing the appellant in this case, which is a fake case, fake client, to prove an existence of a common law marriage in Colorado. But I'm actually going to be using real Colorado law. My professor is going to be the judge, and I'm going to be talking to her the entire time on my other laptop, which you will see shortly. It's a 10-minute oral argument. So to prevent this from being a long, drawn-out intro, I am going to cut the video here and take you straight to it when it begins. See you then.
Mr. Martin,
Good afternoon.
can you hear and see me okay?
I can.
All right, and I can hear and see you okay.
Okay.
Do you have any questions before we begin?
Nope.
All right. Is counsel for the appellant ready to proceed?
Yes, Your Honor.
You may proceed.
Good afternoon, Your Honor. May it please the court. I'm Lamar Martin, and I will be representing the appellant, Mr. Bradley Copper, in this matter. Today, I'll be arguing why this court should reverse the trial court's denial of Mr. Copper's motion in limine because evidence in the record sufficiently establishes the existence of a common law marriage between Mr. Copper and witness Miss Stephanie Fernanda. Your Honor, this case is about a celebrity couple who permanently resided together in Colorado and consummated an agreement to be common law married and thereafter represented to others by words and conduct that they were husband and wife for almost 6 years. Thus, Mr. Copper can assert the spousal privilege under Colorado law to protect Ms. Fernanda from testifying against him. Colorado has long recognized the validity of common law marriages, and the continued recognition of such marriages in today's society, quote, serves as a means of protecting the interests of parties who have acted in good faith as husband and wife, end quote. Colorado courts take no single form of evidence to prove the existence of a common law marriage. Instead, it recognizes, quote, any form of evidence that openly manifests the intention of the parties that the relationship is that of husband and wife, end quote. Here, substantial evidence exists in the record for Mr. Copper to prove the two elements to establish a common law marriage. First, a mutual agreement to be married. Second, a mutual and open assumption of the marital relationship. And before I reach my argument, Your Honor, I want to address a few facts in the record that the trial court did not include in its findings of fact, which ultimately led to an erroneous conclusion of no common law marriage. Since March 2nd, 2014, both Mr. Copper and Ms. Fernanda subjectively believed that the written agreement that they executed made them husband and wife under the common laws of Colorado. 5 days later, an article was published in the Aspen Mountain Press that explicitly recognized their marital agreement and congratulated them for it. Thereafter, every year, they entertained a close mutual friend, Miss Jen Lawrence, at their Colorado home, and she testified that, quote, figured that they were married. Even when work required them to be outside of Colorado, they still demonstrated marital behaviors together, where another close mutual friend, Miss Sarah Posen, testified that she spent time together with them in either New York or Los Angeles every year and perceived them to be madly, quote, madly in love, end quote, and married as well. in light of these facts, this court should reverse the trial court's denial of Mr. Copper's motion in limine based on two reasons. One, Mr. Copper can demonstrate that he entered into a marital agreement to be common law married with Ms. Fernanda. Second, he can demonstrate that he had a mutual and open assumption of the marital relationship with Ms. Fernanda. Your Honor, Mr. Copper and Ms. Fernanda mutually agreed to be married. The two essential elements that proves the existence of a marital agreement is mutual consent to be married in the present, followed by two, mutual public acknowledgement of the agreement. Here,
So one of my concerns is about the mutual agreement. It seems to me that Bradley is very interested in being married. He asked her to be married. He calls her his wife in public, but I don't see it reciprocated. She does not take his surname. She does not call him husband in public. She has frequently rebuffed his questions about being married. So how can I reconcile those concerns?
respectfully, Your Honor, Ms. Fernanda made Mr. Copper aware of common law marriage in Colorado. She testified that, yes, he wants to make it official, but she stated to him that she didn't believe that they needed official government-sanctioned document in Colorado. Given their co-celebrity status, she believed that it would be a, quote, circus, end quote, for the national press and paparazzi to put the wedding out there. So she believed in the common law marriage. Which brings me to my second point. Mr. Copper and Ms. Fernanda, believed that they were mutually consented to be married. So mutual consent can be found by looking at the intent of the parties to be married and the mutual understanding of each party's intent. For example, in the state of Buer, the Colorado Supreme Court recognized a common law marriage where the man went to the home of the woman and expressly stated to her that he wanted her to be his housekeeper, and thereafter they lived together ostensibly as husband and wife. Here, Mr. Copper and Ms. Fernanda had a mutual, spontaneous feeling to be married to each other and thus performed a private, self-officiated ceremony. They mutually understood their shared declaration of intent on a scroll that stated, quote, "I choose you for life," end quote, and they mutually understood what that declaration represented. This is
Even though Colorado allows for common law marriage, it's still a very special and solemn and serious commitment. How seriously did this couple take this commitment if they didn't even use their real names on this scroll?
Respectfully, Your Honor, and this is where the trial court failed to consider testimony surrounding the context of the parties' mutual understanding in signing the scroll in their movie characters' names. Under Colorado law, an agreement does not have to be in writing. Any language or declaration of intention that is mutually understood between parties to accept each other as husband and wife is sufficient.
What case is that from, Counselor?
Smith v. People. Before signing the scroll, they discussed and agreed on the unequivocal connection between their upcoming movie characters' marriage storyline and their in the moment intent to marry each other. On the record, Ms. Fernanda stated at page 144 that the characters, quote, "The characters are mirror images. They are musicians who fall in love like me and Bradley. And we thought that it would be sweet and fitting to recognize our relationship by signing the scroll in our names." Likewise, on the record on page 164, Mr. Copper stated, "It wasn't just any movie character, it was the name of the character I played in the movie I starred in the love of my life." Thus, they intelligently separated between fiction and their actual reality. Thus, this conduct is more than adequate to prove that Mr. Copper's marital agreement with Ms. Fernanda is not fraudulent. Which brings me to my next point. Mr. Copper and Ms. Fernanda publicly acknowledged their agreement immediately. Under Colorado law, a marital agreement cannot be held in secrecy. In Cordes v. Ryan, the Colorado Supreme Court found no common law marriage when man and woman concealed their marriage from the Denver people. Here, less than 5 days, Mr. Copper and Miss Fernanda voluntarily disclosed their marital agreement only to Aspen journalist Miss Amy McAdams. And given their cold celebrity status, they did not want to let the national paparazzi know of the marital agreement that was constantly followed around. But here, they only wanted the local press of Aspen to know. And contrary to the trial court's findings that Miss Fernanda did not refer to Mr. Copper as her husband, she regarded herself as a newlywed to Mr. Copper in her interview with Miss McAdams. So in closing, the trial court erred in properly assessing the quality and quantity of evidence that exists in the record that clearly supports a common law marriage. There is no evidence in the record to suggest that Mr. Copper entered an agreement with Ms. Fernanda in anything other than good faith. And we respectfully request that this court reverses the trial court's denial of Mr. Copper's motion in limine. Thank you, Your Honor.
Clearly practiced and you had clearly rehearsed. You had written out some nice things, I think, especially for the introduction. Things that I think you could improve upon if you were to do this again, which I think you should.
Okay.
I think if you're interested in mid-court, you should consider it.
Okay.
You've got the demeanor and the stage presence.
Yeah.
So things that I would work on for next time. It took too long to get into the meat of your argument.
Mm-hmm.
The facts were too long.
Mm-hmm.
There was a lot of stuff in the facts that we didn't need.
Mm-hmm.
That you could kind of just cut down and generalize.
Yeah.
I didn't need to hear about exactly who testified to what. Just like
Yeah.
a general overview
Yeah.
of facts.
Yeah.
It wasn't until like past the 4-minute mark where you even referenced a case. And I think you were quoting from cases and referencing cases, but not giving me the names of the cases.
Okay.
So I think you were like, even with Smith v. People, you were like, and here's the standard. And I was like, I know that's right from a case, but you should say, as in Smith v. People.
Okay.
And,
Yeah.
so more case references.
Yeah.
That was the big thing that I would have said more.
Okay.
More case references throughout.
Okay.
So that I know you're not just making this law, that it's
Right.
really, and then give those examples. That's the one thing I'd work on.
Okay.
And forensically, there was a little of that. Did you feel it?
Yeah, just because I just, kind of get into it, so.
There's no podium, probably. It's a weird setup.
Well, I mean, I'm standing up, and I don't have a podium, so it's just kind of like there's nothing really in front of me.
Yeah. But if you were to do moot court, you'd have a podium, so you'd be able
Yeah.
to. That was the only forensic thing.
Okay. I mean, I probably could have.
The substantive thing is more cases.
Yeah, I probably could have sat down, and that wouldn't have happened.
That's okay. I like that you were standing.
Okay.
Do you have any questions for me?
No, I enjoyed it.
Good.
Thank you for being my professor on this second go round at law school. So
You're doing great.
yeah. So
You're doing great.
Yeah.
The second go round is for you.
yeah, no, it's truly been a pleasure and honor, and they just did a story on me on GSU Law.
That's great.
It's in the news. It's like in the news section, the communications department. So
I'll go check it out.
yeah, check it out.
All right. Good luck with finals.
All right.
Take care of yourself.
Okay, you too. See ya.
Bye.
All right. Well, there it is, my friends. Rematch of my oral argument for spring 2020. Did I blow it out the water? Probably not. And I wanted to include my professor's feedback in the video. I hope you are able to hear her, because I'm not scared to share the feedback. I'm not scared to share how I did and just this whole video period, because law school is not about being perfect. It's about getting better It's about stepping out and just putting our full selves in it, full courage, and just overcoming it. Just being in that moment, being in that fire. And whatever becomes of it, okay. We'll make it better. We'll get better. And that's all that matters. Let me do this a couple more times down the line and watch me master it and get it down. That's all that matters. How I did this time, okay. At the end of the day, I don't want to be in the courtroom. I want to be in the deal room, baby. I want to be a master negotiator, sports law, negotiating contracts, multi-million deals. That's what I want to do. Doing this stuff is just a part of law school. But I'll take it. Either way, I believe I will get a good grade on it because we got that master curve due to the coronavirus. So, hey, the curve will be in my favor. But just wanted to show you my rematch oral argument. Hope you enjoyed it. And we're going to keep going at it. 1 down, 2 to go. Keep these finals preparation going, baby. Let's go.